All rise. The United States District Court for the District of Nebraska is now in session. The Honorable David L. Peaster, Magistrate Judge presiding. Please be seated.
Mr. Russell.
Your Honor, there are two separate matters here. Case number 405-CR3039 and 405-3091. The court has on its own there's an amended petition for action on conditions of release. There's also an action on conditions of release. The court has on its own motion also indicated to the counsel and defendant that it wished to address the issue related to whether an evaluation was appropriate under Title 18 United States Code Section 4241. These all involve the case involving United States versus Thomas Miller.
Mr. Shuffle, is the defense ready to proceed?
Yes, Your Honor. I would like to note I do appear here this morning as counsel of record. I would like to note that as of 2 days ago, my client has indicated to me that he no longer requires my services. I've essentially been fired. I understand that I remain as attorney of record until it's ordered by you. So prepared to proceed under those conditions, Your Honor.
All right. Mr. Miller, as you know, a petition and an amended petition have been filed alleging that you have violated the conditions of your pretrial release. You are entitled to a hearing on those allegations. The government has the burden of demonstrating that those allegations are true. If I find that they're true, either because you admit them or because I find that from the evidence adduced at a hearing, then I must still hear from both sides on what, if anything, I should do about it. I may revoke your order of release and put you in custody. I may release you under different or additional conditions, or I may do nothing depending upon how I find the circumstances. Do you wish to admit or deny the allegations?
I do not consent, I do not accept, nor do I intend to accept or consent. And who, by the way, who are you speaking to?
I'm speaking to you. I take that
who
as denial.
Who is you?
I'll ask the
I'm the natural person. Are you talking with me, or are you talking with the fiction guy?
Are you the Thomas Earl Colon of the family Miller?
That's my family name. It's not my fiction name.
The record will reflect that the defendant is before the court. Mr. Russell, you may call your first witness.
Your Honor, the United States would call Fred Samway.
Please come forward to the clerk's desk to be sworn.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth to the best of your knowledge and belief?
Yes, I do.
Go ahead.
Would you please state your name for the record?
Fred Samway.
Mr. Samway, how are you employed?
I'm a U.S. Pretrial Services Officer.
As part of your duties, have you been responsible for supervision regarding Thomas Earl Miller?
Yes.
Is Mr. Miller in the courtroom here today?
Yes, he is.
Would you please point him out?
I do not consent or do not accept.
It's taken as an objection and it's overruled. Go ahead.
What was the question?
Would you please point him out?
He's sitting at the defense counsel table.
Can you describe what he's wearing?
I do not accept.
A blue denim shirt.
If you wish to remain in the courtroom, you must abide by the rules of procedure in the courtroom. If you insist on interrupting the witness or speaking out of turn, you will be removed. Do you understand that?
I declare for the record that I'm here under duress, under threat, coercion, intimidation, and fearful of my life, harm and damage being done to me. And I further declare I do not consent to being forced to come here. I am here against my consent, and I do not accept any offers that you may have made forcing me to be here. I do not consent to it.
All of that is overruled. Go ahead.
I rest on my paperwork that is on file in the court. I'm a natural flesh and blood, de jure sovereign man.
Okay. Go ahead.
I'm here to tell you that I do not
Sir,
consent.
do you wish to be put in custody at this time?
I continue to accept.
Do you wish to be put in custody at this time?
I do not accept and I do not
Do
consent.
you wish to be? You have one alternative here. Either cooperate or you go to jail.
I do not consent and I do not accept, nor do I intend to consent.
I find the defendant in contempt of court. I ask the marshals to place him in immediate custody. We are in recess.
This is a
Court
notice.
is in recess.
You touch my private person, you're going to be spent 20 years in jail.
Mr. Miller, go ahead.
And you're going to be under custody for...
All rise. Court is now in session. Please be seated.
We reconvene in the matter of the United States of America versus Thomas Miller. The record should reflect that counsel are in the courtroom as well as the gallery and court personnel. The defendant has been removed from the courtroom pursuant to the civil contempt powers of this court until he decides that he's going to cooperate, and in addition, under Rule 43C1C of the Federal Rules of Criminal Procedure. It is also clear from the record, short and scant as it is, in this hearing earlier while he was present, that he has admitted to being the person who filed numerous documents which are included in the court file and which have nothing but gibberish that is totally incomprehensible. He refuses to be supervised by pretrial services, and he refuses to acknowledge the power of this court over his person and the jurisdiction of this court over his person. I think that I should hear from counsel on whether he should be committed to the custody of the Bureau of Prisons for a mental health examination, and if so, whether he should continue to be taken in custody or should be released to surrender himself for an institution. Mr. Russell.
Your Honor, with respect to the question regarding custody, the United States would recommend that the defendant be detained pending an evaluation by the Bureau of Prisons. Anyone can look at the filings. In addition to what was happening here today, anyone can look at the filings that the defendant has made and indicate that the defendant clearly does not view himself as being subject to the jurisdiction of the court, but also the filings themselves are so incoherent that they just evidence a real question regarding his capacity under 4241 to render himself effective for his own defense, or whether he really and truly understands the nature of what's going on. We could sit here for the next hour and go through line by line some of the things that he's filed, and they're just. I think the court is absolutely correct in calling them gibberish, but I think it's not just an individual who is trying to gain attention. This is somebody who has clearly indicated that he is not going to be subject to our court rules and subject to the jurisdiction of the United States. He's also not being subject to pretrial services because he has not reported in. All he has to do is call, and he hasn't reported in since September 26th. He's clearly evidenced an indication that he will not comply with the court's orders. An evaluation is appropriate. I don't believe in an evaluation to an outside facility would be valuable to the defendant. I think he has to have to be evaluated through the Bureau of Prisons because I think those are those individuals within the Bureau of Prisons have the best, in the best experience in determining whether somebody would be willing to participate in their own defense. And so we would recommend detention. And we would recommend that the defendant receive some type of evaluation.
Okay. Mr. Shuffle.
Your Honor, understandably, this is very difficult given the circumstance, but I would concur in the recommendation of government counsel. I believe it would be in the best interest of Dr. Miller to be evaluated. I have seen a deterioration in my attorney-client relationship with him. One time, I believed I was headed in the right direction, and he was taking my advice, and that has deteriorated. I had recommended to him when I saw his filings that he seeks some sort of assistance and evaluation voluntarily. He chose not to go that direction, and so unfortunately I do believe this is in the best interest of Dr. Miller, and so I would concur. As difficult as that is my position. Thank you.
Thank you. I will enter an order then reflecting these proceedings and also directing that the marshals transfer him to a Bureau of Prisons medical facility so that he can be evaluated over a period of time. And once that has been completed, then a report will be provided to the court. Counsel will be given copies, and at that point we'll have an additional hearing to make a make a determination as to whether he is then competent to stand trial within the meaning of the appropriate standards. In the meantime, Mr. Scheffel, I'm going to ask that you remain in the case because if indeed he is incompetent, then his firing you is of no force and effect anyway. So we'll have you stay in the case and, to the best of your ability, represent his interests, assuming that, well, as best you can. With that, is there anything else that we should address at this point?
Your Honor, just for the record, will the court also be entering an order that will take the trial and the sentencing off the calendar until the Bureau of Prisons recommendation?
Yes. Anything else for the defense?
Nothing, Your Honor. Thank you.
All right. We'll be in recess.
Court is in recess.